Well, efforts are now underway across the country to block President Trump from the 2024 ballot using the 14th Amendment. But New Hampshire's Secretary of State says there are no legal grounds to do so. Let's bring in criminal defense attorneys Bob Bianchi and Lexie Rigden. Thank you both for coming on. This is great to be in New York City with both of you. I want to put this up on the screen because, well, actually, I don't. I want to hear from him because this is what the New Hampshire Secretary of State said about former President Trump and the 14th Amendment.
There is no mention in New Hampshire state statute that a candidate in a New Hampshire presidential primary can be disqualified using the 14th Amendment of the United States Constitution, referencing insurrection or rebellion.
A lot of back and forth on this, Bob. Would you agree with him or disagree?
Yeah, I do agree with him. You know, listen, I don't care what your political persuasion is here. This is a very, very dangerous, slippery slope we're going down. There has not been a factual determination by anybody whether or not there has been a rebellion and insurrection. And notably, there's not even an indictment for that. There was an impeachment proceeding. There was a not guilty verdict, if you will, in the impeachment proceeding. There has not been a trial. So where are the facts? Who determines these facts? And if we start going down that slippery slope, we're going to have blue states having red candidates off the slate and red states having blue candidates off the state. This is very dangerous.
And that's the worry, Lexie, because you really can. You know, you have states like California, you have states that are blue, really blue, like New York, and they're going to say, oh, no, we're not allowing anybody on the ballot. And you think, well, it has to be uniform.
Exactly. And people have dragged Trump for years over what happened on January 6th, saying it was an affront to democracy. The real affront to democracy would be some official in a state saying, you know what, you're not on the ballot. You're not going to be able to be on the ballot because I didn't like what you did on a certain day. I thought it was a rebellion because the left is saying that this is self-executing. So there doesn't have to be any determination to get them off of the ballot. Now, obviously, that's going to be subject to court involvement if it happens.
I want to move on because this is something we cover a lot. It's the whole parents being, the schools keeping secrets from parents. The First Circuit Court of Appeals, right, are very suspect about schools keeping gender secrets from parents. And Bloomberg writes the following here, quoting, the First Circuit appeared open Wednesday to the idea that parents have a constitutional right to be alerted when their child uses new pronouns at school. It goes on to say, but cast doubt on whether that right extends to choosing how teachers refer to their child. I mean, they went into this whole private school, public school thing, and you've got to have all the information to decide whether or not you want to put your kid in private school or public school, and the school has to give you that information to make the proper decision.
Trace, listen, the schools, it's compulsory that a child goes to school. And when the child goes to school, it's called parents, locus parentis. They stand in the place of the parent, not as a substitute for the parent. And what is happening right now is that they are withholding information from the parents in a dubious way, which is creating a fissure and a friction between the student and the parents. And so I just can't imagine when they talk about in the legal terms shocking the conscience. To me, nothing could be more shocking that when you don't know what it is that these teachers are doing, educating or talking to your child about, it should be the family that's making those decisions, or at least they should be apprised as to what those teachers are telling them.
What's he leaving out, Lexie?
It's unbelievable that we live in a world where it's newsworthy that they're questioning this. They should be questioning it. Everybody should be questioning it. What should be newsworthy is that there are lawyers actually standing up and saying, well, teachers can't possibly be expected to tell parents everything that goes on with their kids, who they play with at recess. And that's why that judge said, there's it's a much bigger issue what they are identifying as than who they're playing with at recess.
I have said this 1,000 times. You cannot give a kid an aspirin without picking up the phone and calling mom and dad.
The school nurse would not let my kid have a cough drop the other day, and good job for her because he'd be going in all the time if she did.
So a federal judge has now halted an order by the New Mexico governor, remember, to suspend open and concealed carry of guns. The New Mexico GOP chair said the following, watch.
There are limits to everyone's power, even the governor's power, even the president's power. No one is above the law, and that's our message today to the governor. You are not above the law, Governor.
I'm told I have 10 seconds for each of you. Bob, your thoughts on this?
You cannot overcome the legislature, passed the law. It's the will of the people. If you want to change it, change the law. You just don't do things by executive fiat.
Lexie.
This is a political stunt, and she knows it. She has even gone on and said, we'll see if it's constitutional. This is something to cater to some portion of her base, and it's completely unconstitutional.
Lexie Rigden, Bob Bianchi, great to see you. Thank you.
Good to see you, too.
Well, parents.